Welcome to Balcostics ED. We thought it best to start our interviews with a topic that looks at both law and research. I'm your host, Abigail, and our topic this week is the Trademark Confusion Survey, the nexus between research and law. Trademark confusion surveys bring together both my passions, research and law. In the world of intellectual property, many companies are now ensuring that their trademarks are not confused with their competitors. To speak on this, we have Mrs. Kelly Ray Fisher Campbell. She's an attorney and holds a Master of Laws in Intellectual Property. We also have Mr. Llewyn Thomas. He's the Managing Director of Balcostics Research. He holds a Master of Science in Economics and has been in the field of research for over 10 years. Thank you for joining us in this discussion.
Thank you.
No problem. Thanks for having me.
It's only fitting that we are the ones here. Good.
All right, let's just get the ball rolling. Kelly, could you tell our listeners what exactly is a trademark?
Okay, no problem. So a trademark basically is a sign or any shape, any distinctive design, letter, color combination that is used to identify a good or a service that is produced or provided by a particular person or a business. So for example, Balcostics, the name Balcostics, your trademark, the sign that you guys have, that would be considered a trademark, you know, Book Fusion. Some of the popular trademarks would be like the NCB sign in Jamaica. Things like those are generally what trademarks refer to.
Great, thanks Kelly for that explanation. In recent years, the courts in the United States, Canada, and the United Kingdom have been seeing a drastic increase in the number of cases where surveys has been accepted in trademark infringement and passing off cases. Kelly, how prevalent is trademark litigation in the Caribbean?
Well, while I think registration and just the recognition of trademarks have definitely gained traction over the past decade or so, and you know, disputes and issues have kind of arisen more so than in past years, I think we're leaps and bounds away from, you know, what the UK, US, and Canada go through with the amount of claims they see even on a monthly basis. I would say per year, a handful of cases in the different territories throughout the Caribbean. And definitely at the Supreme Court level, just a handful of cases. But you do find that a lot of issues will come up and they get settled out of court. So there will be somebody who identifies a trademark that might look similar to theirs, or
Okay.
a mark that's infringing, and they'll come and they'll settle out of court.
Okay, so it won't become public, or they won't even, yeah.
Not necessarily. It usually reflects the resources of the persons who are, you know, who have the issue. So you'll find that a lot of the times it will go, they'll retain an attorney who will, you know, send maybe a cease and desist to the next side. A discussion might be had. They might also retain an attorney. And sometimes you find that these matters are quickly settled. There are some cases where, you know, where the reputation of the company or the mark in question, the marks in question are very big and there's a lot of value there. It tends to end up going to court. So we're not a very litigious group of people when it comes to trademarks just yet, but we do have a handful of cases. In Jamaica, I can say a handful will show up each year.
Yeah, but because I think as well to Kelly that in terms of litigation, it would require a lot of money to
Yes,
especially for smaller companies, you would not have that type of budget to.
No, and not even without the smaller companies, you know, going to court, a lot of the times if you are able to gather enough evidence to say to an individual or a person that you think might be infringing your trademark, if you're able to present a clear enough case of infringement, people are minded to settle or agree, especially if they themselves go and seek legal counsel, and counsel says, you know, in some ways there might be a likelihood of confusion, there might be a case for trademark infringement. And sometimes you have lawyers or attorneys advising persons even in the creation of marks, and so persons can kind of navigate the waters in a way that they ensure that infringement just does not occur.
Okay, good.
Great, Kelly. So let's join Luann in this discussion. Luann, Balcostics did a trademark survey. Tell us generally about the survey that was conducted.
Okay. Yes. So some time ago we did a trademark survey, and as Kelly mentioned, these were two big international companies. We can't get too in depth as it relates to the name because of confidentiality issues and confidentiality for our clients. But we can call it's two big international companies, and they had issues that were ongoing across different geographic locations. So I think with trademark surveys as well, and I guess Kelly could actually confirm these type of things, is that you have to is in each jurisdiction that they have to do these trademark surveys to test if confusion is an issue in that particular geographic location. So in Jamaica, they selected us, and they selected us because of the fact that Balcostics, we had an attorney on our team who is very involved as it relates to contracts and logistics as well. So so when our proposal, we were selected, and that was one of the reasons that they indicated that they selected us, because we had an attorney, and we brought that background to this project. But for our all island survey we did, is what you call a mall intercept survey. So we visited several malls and shopping centers across Jamaica, because that was where the target market was for this particular product. And we can say it was a watch, just a general putting it out there. So as I mentioned, so in terms of these confusion surveys, it's probably the most important aspect of it is to ensure that you're targeting the right persons. So in our case, we surveyed employed Jamaicans who were 18 years and over, and who had purchased a watch in the past 3 years, or plan on purchasing a watch in the next year. So we had a rigorous screening process, and we actually, even though we visited the 14 parishes across Jamaica, is areas where people, the potential customers for these watches would be. And that is very important, because after doing our checks as it relates to, we didn't find a lot of case studies in Jamaica, but we used case studies that were accepted in the courts in the US and across different international jurisdictions as it relates to what is it that they look for in these type of surveys. And in terms of the target group, that is the most critical, because if you're not asking the right persons the questions, it would not be relevant. And in terms of the sampling that we did, so our sampling, as we mentioned, in terms of screening, it was a sampling in terms of to reduce sampling bias. In this case, we used stratified random sampling because, as mentioned, we weren't interested in every shopper, or is shoppers who met a specific ideal. And that in this case is persons who purchased in the past 3 years or who plan on purchasing in the next year. So that was in terms of our approach. And for these surveys as well, it's all about perception. So respondents, they would provide answers to different questions relating to their perception as to whether they believe 2 marks. And how we designed the questionnaire, you actually had an illustration of the mark. So you had an illustration for mark A and mark B, or watch A and watch B, in terms of that trademark, and then persons, we ask persons, you know, is it a case that you believe that it's the same company that own both of these marks? And we basically get a confusion rate based on the percentage of persons who said yes, they believe it's the same company that own both marks. So yes, so I kind of discussed this already. So respondents were asked to explain why. So the why they thought the marks were owned by the same company, or why they thought it was not owned by the same company. So this is now a more open-ended approach in terms of asking these open-ended questions. Excuse me. So we ask, so the why is very important because it helps as well with bias. So you understand what is causing the confusion, why they think that watch A is from the same company as watch B, or why they think that it's a different company. So that kind of give a lot of insight as well into consumer thinking. And in terms of and in terms of the confusion surveys, the main objective for these type of surveys is to determine the likelihood of confusion among consumers. And I mentioned in terms of watch company A and watch company B. So, you know, basically I mentioned this already as well. So, you know, do they believe that, you know, company A and company B in terms of the marks is from the same company? And just a quick overview of how we would go about analyzing these type of surveys. So the most important would be the percent of consumers who thought both marks were from the same company. So once we ask the persons the perception as it relates to the marks, we actually would get a percentage value that we can use. That is what we actually present and use as it relates to the likelihood of confusion rate. So for argument's sake, you might have a likelihood of confusion of like 30% of all consumers were confused. And even, you know, so when you have even this level of confusion, it's still significant in terms of the courts, I believe. And as I mentioned before, in terms of the qualitative reasons, so it's not just about them indicating that they are confused, but getting some qualitative answers as it relates to the actual reasons why they were confused with the two marks. So that's that for me.
Thanks, Louis. That was indeed informational. Kelly, the courts look to specific indicia of reliability regarding how a trademark survey was conducted and performed. Could you tell us some of these?
Well, generally, surveys can be very important to determining infringement or dilution of a trademark. And as Luane would have kind of walked us through with that watch example, is that generally the court looks to, when looking for infringement, is it likely to deceive or confuse the public? So getting the opinion of the public can always be helpful in proving or disproving whether you want to establish that, you know, a mark is likely to be associated with another mark, or it's likely to deceive or confuse the public as to its association or origin. So generally, I think the US is very much, it's pretty routine in the US to use surveys in any trademark infringement matter or litigation matter. And admissibility of the survey generally depends on like the qualifications of the experts, the helpness of the findings, and the reliability and fitness of the findings. And the reliability and fitness generally depends on the trustworthiness of the survey itself. And usually when looking at the trustworthiness of the survey, they're going to look at, you know, were a sufficient number of individuals surveyed, were there specific controls used, were specific controls created to measure if any portion of the survey was confusing in itself, whether the questions were leading, did it follow a proper format, and if a percentage of survey respondents were called to verify the accuracy of their answers.
Yes.
A substantial amount of case law would exist, which would provide insight into how to conduct and prepare, proper trademark surveys that can be admissible in court. Even just to point out, even before going, starting a claim or starting a matter, is generally very prudent for trademark owners, especially if you think your trademark might be infringed or you might infringe another person's trademark. It's generally prudent to ensure that you do a survey to kind of get a feel of what the public perceives. How do they look at this trademark? Are they likely to associate it with another mark? And there's another way in which you can infringe on a trademark as well, is where the reputation of a mark or is so big that even if someone is to use the mark or something similar in a trade or service that is not related to what you're using the mark for, it would take an unfair advantage from the original mark or its distinctive character or its reputation. So sometimes it's even useful to do a survey to find out, is the public familiar with your mark? What is the general feeling? What do people think of when they see this particular mark? So surveys can be very useful in not only trademark litigation, but trademark registration and general trademark management.
Yeah, good points, Kelly. And even in our case for this watch company trademark survey, confusion survey that we did, we actually, so after presenting our final report to the company, they actually presented to the court. I think it was in the form of an affidavit, and the company, not our company that we were working for, but the opposing company or the company that they had the matter with, they actually had other their research experts do a response where they were trying to identify areas of weakness or issues with our survey. So even with these type of surveys, you have to be so careful, and you have to be sure that you're following international standards. And as you mentioned, there's a lot of established precedents as it relates to how you should go about doing these type of surveys and what are some of the best practices. And having an attorney on our team again was also very good here as it relates to Abby, and she could probably say a little on this in terms of our background research into how we would actually approach this type of survey, because we had to do an affidavit and they responded to us as it relates to what they believe were issues with our approach or with our methodology. Unfortunately, in this case, they did respond, so they had their international research persons respond to us, but it was basic issues. They really couldn't find any major issues, so we just responded back to them with another affidavit to just to clarify basically what they wanted, a few clarifications, but they didn't find any issues as it relates to throw out or invalidate our results. So that is something for us to note as well.
I just want to point out for our listeners that an affidavit is a sworn statement, and we outlined the methodology, we outlined the cases that spoke to our matter in this affidavit. So Luann, based on your experience, what are some of the key points when conducting a confusion survey?
So you have to ensure that you're targeting the right persons. In our case, it was employed persons. So even with how we went about doing our sampling and the stratified random sampling, it had to do with getting information about the Jamaica labor force, and we used that to calculate a sample size that we could actually work with. So it don't make sense we interview persons who don't have the ability or the capacity to pay. Target market, well, target population, that is probably one of the most important things I would say, in terms, ensure that you have the right methodology, the proper case studies, in terms of reviewing case studies, looking at the international standards and try to follow it. That's how I would put that.
In closing, ensuring that a survey is conducted in the perfect environment is key when conducting a survey for use in litigation proceedings, because trademark surveys are often determine the outcome of a trademark litigation. Thank you, Kelly and Luann, for taking the time to discuss this topic with us. You can subscribe to our channel and get notification on other research topics. Until next time, stay in the know. Our sponsor for this episode is Book Fusion, delivering open and accessible digital library solutions to schools, businesses, and governments globally. For more information, visit them at www.bookfusion.com/business.